So, now let us look into the second writ, the writ of mandamus. Mandamus is an order issued by the court to any public authority to do a specific act or forbidding the same authority from doing some specific act. So, the mandamus is a writ order issued by the Supreme Court or the High Court directing a particular public authority either to do something or not to do something. This writ is mostly used to enforce the public duties, and when public authorities fail to perform their duties, the writ of mandamus is usually issued. The purpose of the writ of mandamus is to keep the public authorities within the limits of their jurisdiction. When the writ of mandamus can be granted, there are several grounds on which. The first one, there must be a public duty. That means the public authority is under the public duty to perform something. So, such public duty must be either imposed by the Constitution or by a statute or even by a executive order. So, what is important under the public duty is that it is the nature of the duty, but not the form of the body. That means, whether you are a public officer or not is not the issue. The issue is whether you are exercising a public duty. That is most important. That means, even if you are a private person, but exercising a public duty, the writ of mandamus can be issued. So, in Tata Cellular versus Union of India, the court held that if a government contract was conferred to a private person in violation of a law, the court could interfere by issuing of the mandamus, as it could be unreasonable under Article 14. Therefore, we are not looking whether you are a public authority or a private authority, but the question is whether you are exercising a public duty or it is a private duty. If it is a private duty, no writ could be issued. If it is a public duty, writ of mandamus could be issued. The second ground that you have to satisfy to claim this writ is that the enforceable right. That means, the petitioner has a right to compel the authority to perform the duty, and that right must be an enforceable right. For example, if the duty is only a discretion of the authority, then the petitioner has no enforceable right to ask him to exercise that discretion. For example, an employee cannot ask an employer to declare a dearness allowance. Therefore, if an employer is not declaring a dearness allowance, you cannot approach the court and ask the court to issue a mandamus directing the employer to give dearness allowance, because it is a discretion of the employer. Similarly, the third one says that the enforceable right what we are talking about must be an existing legal right. That means, when you are asking the court to issue a writ of mandamus, there must be an enforceable right, and the enforceable right must be existing right now. If that is not existing right now, it used to exist, then the writ of mandamus could not be issued. And the fourth condition that you need to fulfill to get the writ of mandamus is there must be a legal duty. That is, when you are having a right, a legal right, the public authority must be under the legal duty to perform, and the duty must be mandatory and it should not be discretionary. And the fifth one, the most important one, is that there must be a demand and refusal. That means, to claim mandamus, first the petitioner must have demanded the authority to perform their duty. Upon demand, if the authority refused to perform the duty, then only you can go to the writ of mandamus. So, without demanding the authority, you can't go to the court and ask the court to issue a writ of mandamus. And further, the most important thing is, when you are demanding, whom you are demanding? Are you demanding a right authority or a wrong authority? So, if you are not asked and demanded from the right authority, you demanded a wrong authority and it was refused, there is no writ of mandamus could be issued against you. So, the grounds on which a writ of mandamus could be issued: number one, when the authority exercising without jurisdiction, or when the authority exercises excessive jurisdiction, or abuse the jurisdiction, or violate the principles of natural justice while taking a decision, or they are performing an act which is not supposed to be performed. In all the cases you could ask for writ of mandamus. And when this writ would not lie, that means when this writ would not applicable. The first one is a writ cannot be issued against a private person exercising a private function. It is only for a public function, and you cannot enforce this mandamus to enforce a civil decree, because to enforce a civil decree there is a special procedure is there. So, you have to follow that procedure. And you can't even ask this writ against any parliament or any legislative body to make a law or to frame a policy or to frame rules or regulations, because those are the prerogative of the legislature. So, court cannot interfere with the legislature regarding their legislative function, is not allowed. And courts also reluctant in issuing the mandamus for giving general directions. For example, if a petitioner goes to the Supreme Court and asks the Supreme Court to issue a direction to the railway minister to improve the general conditions in the railways, that's not allowed. And mandamus is also not issued to enforce a liability that is arising out of either under a contract or tort, because they are being a private remedies. You can't ask for writ of mandamus.